I am George Geis, and today we're going to talk about a corporate law topic that many of you have probably never heard of. It's the law of agency. If you're like me, when I was getting ready to come to law school, I read a bunch of those books on how to succeed in law school. They all have funny names, right? It's like Law School Confidential, we've got something secret to tell you, or One L of a Ride, or like Taming the Law School Dragon, right? I mean, they all think about these wild things. And you can read them if you want. I don't know that I recommend it, but you can. And they'll do you a decent job of telling you about some of the required first-year classes. Classes like contract law, maybe criminal law. They probably aren't going to tell you anything about agency law. Nevertheless, I'm here to tell you today that agency law is fundamental. It's a critical area of the law. And in fact, it's going to be the very first thing you study if you take a class in corporate law. We'll talk about why in a minute. Agency law actually used to be a first-year required class for law students. They took it out of the required curriculum a while ago, but it's a really important area of the law. Okay, what is it? Well, you probably have heard of a movie agent or a sports agent, but the truth is anybody can have an agent. In fact, I'll bet some of you sitting in this room right now have an agent, maybe without even knowing it. And you say, well, okay, so what? Who cares? Well, you should care, because a number of implications follow from having an agent, not the least of which is this. Under the right circumstances, you might be legally responsible for the acts of somebody else. I'll say that again. Under the right circumstances, you might be legally responsible for the acts of someone else. You say, whoa, Professor Geis, time out. I can barely be responsible for my own acts, and now I've got to be responsible for other. And I'm going to tell you, yeah, under the right circumstances, that's the case. And you say, okay, you've got my attention. How do I know whether I have one of these agency things so I can protect myself if necessary? And the short answer is that agency situations, agency relationships require three things. You got to have three things that are present. They result from an agreement between the principal and the agent that the agent shall act on behalf of the principal and be subject to his or her control. Now, this can be really explicit. I could agree with you that I'm going to hire you for, $50 an hour to be my research assistant this summer, and we're going to explore developments in corporate law in Delaware, right? That could be, and you say yes, and that's a pretty clear agency relationship. It might be more subtle. It might be the case that I give you $10 and say, hey, can you go get us a couple cups of coffee? And you say, okay. Either one of those might create an agency relationship because we got an agreement, agent's acting on behalf of the principal and subject to his or her control. Importantly, the control doesn't have to be really detailed. It's not like you necessarily have to micromanage every single thing that the agent is doing. You just have to generally be, overseeing and guiding them on this is, what I want you to do, or this is what I'm asking you to do. Once you've got all three of these things, you've got an agency relationship. And I'll give you a couple of examples of what that might look like. Many of us have heard of a real estate agent. And if we're buying or selling a house, we might, employ a real estate agent to try to help us facilitate that transaction. Similarly, if you look at a corporate executive, someone like, Mary Barra at GM or Satya Nadella at Microsoft, they are going to be viewed as agents of their corporation. They're leaders of the corporation, but they're also agents of the corporation. Microsoft is the principal, Satya is the agent. And in fact, if you think about it for a minute, this is why agency law is so important for corporate law. Sometimes you hear these sayings, corporations are people too, right? Corporations are people too. A few years ago, maybe a little longer than that now, Apple ran a series of amusing advertisements, and they had two characters. They had PC guy and they had Apple guy. I don't know if you remember it, or Mac guy. And they were kind of funny. PC guy was this bumbling, overly formal, stuffy individual that would get into a lot of trouble. And Mac guy was this kind of cool, Keanu Reeves look-alike in Vans, who would slide in and save the day, right? And they were trying to basically personify their corporations. Well, if this was how it really worked, and corporations were people, then in order to know what Apple was doing on any individual day, we would just look at what Mac guy did, and that would be the activities of the corporation. But that's not how it works, of course, right? Corporations are not people. There is a whole interesting set of issues and topics in corporate law related to what rights and obligations do corporations have as a separate legal entity. But they're not people. Now, maybe someday we'll get there, right? Maybe we'll have AI that works with corporations and does all kinds of stuff on its own. But until then, if we want to know what a corporation is actually doing, we've got to look at what its agents are doing, because corporations can only act through their agents. And so the establishment of an agency relationship is going to be critical to understanding how corporations work, when corporations are responsible for things that their employees do, and so on. Okay, with that, I want to put you in the position of judge and jury and ask you to help us decide a couple of legal cases. You have all the law that you need to know. And I want to start with a case that we didn't hand out. So I'll set up the facts of this first case. It's called Gorton versus Doty. Then I'll ask for your thoughts and opinions, and then we'll get eventually to the case that we handed out. So here's the setup. There was a teacher up in Idaho. Her name was Miss Doty. And one weekday, Miss Doty was hanging out by the coffee machine talking to the football coach, a guy named Coach Garst. And she was asking the football coach, hey, I know you've got a game this Friday. Do you have enough transportation to get all the players over to the game? And the coach said, actually, we're a little bit short. We need another car in order to transport the players over. And Miss Doty said, oh, I'll tell you what, I'll let you use my car, but only if you drive it. I don't want some 16-year-old driving my car, so if you drive my car, then I'll let you use my car to go to the game. And coach said, okay, thank you. Borrowed the car, went to the game. We don't know if they won or lost. On the way home, Coach Garst was driving Miss Doty's car when he got into an accident. He crashed her car. And it turned out that one of the students riding with Coach Garst, a fellow named Gorton, was hurt. And let's just stipulate that Coach Garst was driving carelessly. He was driving negligently. He had committed a legal wrong. Now, let's imagine that young Mr. Gorton, perhaps his parents, come into your law firm office and they say, Gorton's hurt. Gorton would like to be compensated for the harm. Put on your plaintiff lawyer's hat. Who are you going to think about suing in this situation? Who are the various parties that you might try to go after to recover damages for poor young Mr. Gorton? Any thoughts? Where might you start? You might start with Coach Garst. I would, right? He's the one that was driving carelessly. Well, it turned out that the accident was apparently so bad that Coach Garst had died. And I know, it's shocking. It's shocking. Already law school is shocking. And I guess he didn't have the estate or the resources that were going to be enough to allow the student to recover. So let's assume that Coach Garst is not going to be a viable defendant. Who else might we go after?
Well, Miss Doty, but I would say don't different states have different rules about like driving other people's cars and like who's liable, insurance-wise at least.
There might be a state-by-state decision on this point. This is a little bit of an older case though, right? And so in the absence of specific state laws, we might have to go back and look at first agency principles to figure this out. So you want to say if the coach is not available, let's go after Miss Doty. Why not?
Who else?
Who else? Anyone have another possible defendant? Ooh, a bunch of.
Person who made the car, person who designed the road.
Okay. We might want to know more about what exactly happened and whether it was, Coach Garst driving carelessly or if there was actually a product manufacturing defect with the car.
The school that sponsored the team that.
I would think the school might be a second defendant if the coach is not available. It turned out that at the time, again, this was an older case, Apparently in Idaho, there was some kind of a sovereign immunity protection such that schools were not going to be liable in situations like this. So maybe there's some other defendants, right? The roads, the cars, who knows? But coach is off the table, school's off the table. In the event, Gorton decides to sue Miss Doty, right? I'm going to sue Miss Doty. And so the question we have to answer is whether or not Miss Doty is legally responsible for Coach Garst's negligent driving. And that's going to turn, of course, on whether there was an agency relationship established between Miss Doty and Coach Garst. Here are facts again, or our standards again, that we need to establish an agency relationship. What do you think? Is there an agency relationship here?
Well, Garst isn't using the car on Miss Doty's behalf. He's using it for his own car.
Okay. What about, let's go step by step. What about an agreement? Is there an agreement?
Well, there's an agreement to hold the car, yeah.
Okay. I'll loan you my car. Thank you. Right? Or you can borrow my car. Thank you. What about the control factor? If Miss Doty's the principal and the coach would be her agent, does she have control? Yeah?
I think yes, because she gave conditions and the conditions were met, and that's why she let him drive the car.
So she's certainly not telling him, take a right on Main Street, take a left on 2nd Street. But she's in general directing where he takes the car and how he drives the car and conditions it upon his using the car. There's at least a hallmark of possible control. But you're saying there's a problem with the middle element, the on behalf of. Why?
I would imagine that if it was an agreement to benefit Miss Doty, if they're actually taken for Miss Doty, then it wouldn't be going to a football game that she's not involved in it.
Miss Doty wasn't benefiting from this. It wasn't on her behalf. If the coach was doing anything here, he was doing something that was helping him out. It was helping the football team out. It wasn't helping out the teacher that was loaning him the car. Can anyone here come up with an argument where maybe there is a benefit that Miss Doty would be enjoying by loaning out the car? Yeah.
The success of the football team.
Okay.
Because she brought up do you have enough space on the bus to bring the players? He said no, and then she preferred her car to Coach Garst.
So, school spirit.
Yeah.
She feels good about supporting the school. She's getting the benefit of, feeling that this is the right thing to do. What do you think?
I feel like it seemed reasonable that maybe she could expect like a reciprocal favor in the future, building goodwill.
Okay, so maybe you're building goodwill with the coach. If I loan you my car now, you'll give me good football ticket seats next time around or something. That could be as well, yeah?
She asked him to do it, so I feel like if it's an act on behalf of it has to be beneficial. I feel like a company could sign you on a contract to do something that would be bad to them. It wouldn't make sense, but you'd still be an agent. So just the fact that we don't know how it benefited her, but she asked him to do it, and it was he was doing it on her behalf.
She asked him to drive her car?
Yeah.
She offered her car to him, right? She said, if you want my car, you can use it. We're still going to want to ask, is there some kind of a legal benefit that she enjoyed?
Maybe she has a kid who needs to go to the game.
Okay, we'd want to know maybe a little bit more about maybe one of her kids on the team, and if he doesn't drive, she's going to have to drive. We'd have to explore other facts there.
I don't know if this is high school, collegiate, but if the team has success, there could be financial implications for the institution that
Okay.
should maybe down. That's kind of a.
Yeah, it's high school, right? So I don't know if name, image, likeness has descended down on high school yet, but if it were there, maybe there'd be more resources flowing into the school. It's a theory worth exploring.
Well, she was hoping to benefit by him driving and not the high schoolers, who were the other options.
Okay, and how would that benefit her?
Well, she's hoping that her car will be protected
Okay.
by him driving
Okay.
versus, a 16-year-old driving. Unfortunately, that didn't work out in practice.
Okay, no, unfortunately it did not. So I hear a few theories. Let me ask for a final vote, and then I'll tell you what the court actually did. How many of you would say that, given what we've heard, there's enough here to find that Coach Garst was Miss Doty's agent such that she's going to be liable for the crash? A couple of you. And how many of you say no way? And I'm assuming most of you would say it falls down on this on behalf of. We can put out a couple theories, but if we had to actually draw the line, doesn't seem like it's a real benefit to her. Guess what? The court went the other way. The court said, yes, there is an agency relationship here. Miss Doty is going to be legally responsible for the coach's behavior. Now, this decision's been pretty roundly criticized, right? Most people have said, I don't see any reason how this could be a real legal benefit. You know, they're applying this, they kind of got it wrong. In part, one of the lawyers here was arguing that, well, we all know that if Miss Doty's liable, she probably has car insurance and won't really be paying for it herself. And there was almost a mistrial along those lines. I'm not sure the court got it right, but it's a good example of what it might take to create an agency relationship and how important an agency relationship can be. Let's try a couple more examples. Here's my pen. Are you my agent?
I don't think so.
Why not?
I don't even know what you want me to do with them.
Yeah. I mean, come back to our agreement, act on behalf of, subject to my control. No, they're not present, right? None of those are present. We're not in an agency relationship. The law would classify us as in a donor-donee relationship. I've given you something. That's it, right? We don't know anything more than that. Here's my pen. Can you sell it for me? And you say, okay. Are we in an agency relationship?
Yeah. If I agree, yes.
Yeah, you said okay. Here's my pen, can you sell it for me? Okay. Are we in an agency relationship? How come?
We have an agreement. I'm acting on behalf of you by selling it for you.
Okay.
And I'm subject to your control because you outlined the conditions.
Yeah, I mean, if we wanted to attack the imposition of an agency relationship, we might question whether you're subject enough to my control. I haven't really told you put it on eBay, right, or how to sell it. But probably I think that's enough. Remember, I said earlier that you don't have to have detailed instructions conveyed over to the agent. So probably in that situation, here's my pen, can you sell it for me? Okay, you're my agent. All right, one more. You buy my pen for fair value. It's a UVA Law pen, so it's probably worth hundreds of dollars. And your plan is to try to resell it later for your own profit. Are you my agent?
No, we've not entered an agreement.
Well, we agreed that I was going to sell you my pen.
That's it, though.
Yeah?
And then whatever I do with that pen from then on out is my business.
Okay, so there is an agreement there, though, right? I mean, we had a contractual agreement where you bought my pen. What's that?
At one point.
At one point. So why are you no longer my agent?
Because that is as far as the agreement, the scope of the agreement was just to that interaction.
Okay. We're not in an agency relationship. Anything you do now is not acting on my behalf, or certainly not subject to my control. It's your pen. We're in a contractual supply agreement, right? But there's nothing there that would suggest that you're doing anything on my behalf. Some of you, and the cases can get closer. Some of you might have heard about like a consignment sale. Right, where you put a product on with a merchant and then they try to sell it for you. Those can be really close cases on this sort of spectrum because it may turn on how much of an ability do you have to actually get the product back, right? If you don't like the way that they're performing, you might be able to get. So there's some gray area cases here, but fundamentally, right, in order to have an agency relationship, these are the three things that we're going to be looking for. Okay, let's step back for a minute. So far, we've been talking about the borders between the creation of an agency relationship or something that's not an agency relationship. Now I want to talk about what happens after you get to an agency relationship. Usually the way it's analyzed is to put up three primary parties. There's the principal, the agent, and the third party. Once there has been a relationship established up at the top, so you do have a clear agency relationship between the principal and the agent, there are a whole bunch of legal implications that follow. I'll just put three out there, right? The first one is that the agent can bind the principal to other third parties in contract law. This is a lot of what corporation agents do, right? If you think about, what the CEO of Microsoft or GM is doing, if you think about what sales agents for those companies are doing, in many, many cases, if they sign a sales contract promising to deliver cars to a customer, the agent themselves is not standing behind that contract, right? They're not on the hook if the company fails to deliver the cars. They're acting as a representative of the company that's binding the principal company to the third party that's buying the cars. Now, there's a lot of interesting legal limits here. If you, just because you happen to be an agent for a company doesn't mean you can bind the company to anything, But that's going to be something that you'll have to take on later on when you dig further into this. Implication number 2, the principal might be responsible for the torts or the legal wrongs of the agent. We saw an example of that already, right, with the Gorton v. Doty case. Implication number 3 doesn't really relate to the relationship between the third party and the principal. It relates now to the relationship between the principal and the agent. Implication number 3 is that the agent owes fiduciary duties to the principal. This is a big deal in corporate law, right? The agent isn't just in a contractual relationship with the principal. The agent is actually going to owe duties or obligations. They're going to have to be loyal to the principal. They're going to have to be careful in the way that they carry out the operations for the principal. They're going to have to behave in good faith. And so when you take a class in corporate law, there'll be a whole bunch of different cases and situations, and you have to try to evaluate, do we think that the agent actually carried out their duties responsibly? In fact, it's such a big problem, there's a major area of corporate law known as the agency cost problem. And it really arises because when you've got control over one person's property, you might not always do what they would do. You might not take as much care. You might not behave in as loyal of a manner. You might not make the same decisions as an agent as you would if you actually owned the property that was subject to the situation. I'll give you a quick example. Any of you who drive a rental car, maybe some of you rented one today to come here, right? When you're driving your rental car around, let me just pose one question. I won't ask you to answer. Do you treat that rental car as carefully as you treat your own car? If the answer is yes, you're a good agent, right? You have high fidelity, there's no agency cost problem. But for many of us, we might take the corners a little faster, right? Or we might park it a little less carefully, or we might not pick up the trash in the back seat. Those are all examples, right, of where the agent has control of a property that belongs to somebody else, just like in the corporate context. And a big role of corporate law is to try to incentivize the agent to behave in a proper way, right? But that, again, is a big topic. I want to skip over topic 1, and let's talk a little bit more about topic number 2, situations where the principal might be responsible for the torts of the agent. Now, I need to give you a little more law before we can get into our main case for the day. We're going to be working with a theory called Respondeat superior. Respondeat superior. It's the major theory for when the principal is going to be responsible for torts of the agent. It basically means let the employer answer for the torts of the employee. And in order to have respondeat superior liability, generally you've got to look for 2 things. First, the agent has to be an employee and not just an independent contractor. They've got to be a close agent. There's got to be a fair amount of control over what the principal is telling the agent to do. Second, the tort, the wrong, has to be committed within the scope of employment. It has to be committed within the scope of employment. Usually that means that it is arising out of the agent's purpose to serve the principal. They're trying to serve or further the affairs of the principal. Sometimes there's an alternative test, which is that it's foreseeable that this might arise. This might be the result of hiring this agent to do this obligation. So to quickly summarize, for respondeat superior, we want employee, not independent contractor, purpose to serve, which might mean committed within the scope of employment or a foreseeable result. I'll say a little bit more about the first. What is the difference between an employee and an independent contractor? Some of you might have a general familiarity with this. It matters a lot for tax and for other situations as well. And there are a whole set of factors that sometimes are put out there as ones that are helpful to distinguish an employee from an independent contractor. Here's a few. I'm not going to go through all of them. If you want a mental model in your mind for what's an independent contractor versus what's an employee, you might think about 2 types of gardeners. On the one hand, imagine that you hire a gardener who comes around to your place every couple weeks. You may be there, you may not even be around. They use their own equipment. They sort of get their stuff off the truck. They mow, they blow, and they go, right? You never see them. That's probably an independent contractor. Contrast that with a gardener who's a live-in gardener for a large estate. Think about a place like Downton Abbey or something, right? And every morning the gardener gets up, goes and talks to the owner of the house and says, well, what do you think we should do today? And the owner says, well, why don't you go get out all the equipment that we have here on our property, and today I'd like you to please prune the roses, or let's trim the boxwood. That's a good example, I think, of an employee type agent. So we're going to care about how close is that agency relationship. And we're also then going to care, of course, about whether any wrong was committed within the purpose to serve. Okay, with that, we're ready to apply Respondeat superior liability to our main case. This is the case of Ira Bushey versus the United States. Now, we handed out the case. You may have had a chance to take a look at it before coming to class. If not, we can talk through the main facts here, and then we can try to analyze, what happened, why did it happen, and whether this is a sensible legal outcome. So it turns out that there was a Coast Guard ship that was pulled into a dry dock in Brooklyn, New York. And the ship was, I guess, being repaired and retrofitted in New York. But the Coast Guard wanted to set up an arrangement with the dry dock that the sailors could live on the ship while the dry dock was doing its work. I guess it was for a few weeks or so. And the sailors were going to take some shore leave and sort of maybe do some other stuff. But basically, they were going to live on the ship, and they had a path that they were going to follow to go off and do their shore leave. Well, one of those sailors was named Lane. And Lane decided to go out one night and get drunk. Apparently, Lane got very drunk. And for some reason, coming back after being out at the bars, Lane was walking, along the various pathways to get back to where he was going to sleep. And he passed these 3 valves. And Lane decided that it was going to be a good idea to spin each of those 3 valves 20 times. 20 times each. Well, the valves were the water intake system for the dry dock, and water started flooding into the dry dock, causing this ship to basically lift up, fall over, and smash down on the dry dock, damaging the dry dock pretty badly. Now, Bushey is the owner of the dry dock, and Bushey is understandably pretty upset by the whole state of affairs and said, I don't think this is a good thing. I certainly would like to be compensated for the damage to my dry dock. I guess Bushey maybe thought about suing Lane for a microsecond and then realized that Lane might not be the best person with the resources that would be able to cover the damage to the dry dock. Turns out Lane was quickly court-martialed and dismissed and has disappeared from the situation. So, the Ira Bushey is kind of looking around saying, all right, well, Lane's not going to be a good defendant. Who else might I try to sue here? Last I checked, our government has a lot of money. Check back next year, right? But certainly back in 1963, the government had pretty deep pockets. So Bushey said, well, if I can't recover from Lane, maybe I'm going to sue the U.S. Coast Guard. So Bushey files claim against the U.S. Coast Guard. The theory is respondeat superior. And in order to figure out whether the Coast Guard is going to be liable for Lane's tort, we've got to go through our 2 major issues. First off, was Lane an employee or an independent contractor? Second off, was Lane acting within the scope of employment during the incident? Let's start with item number 1. Tell me what you think. Was Lane more likely to be viewed as an employee or an independent contractor here? Any thoughts? Employee? Why?
I feel like being like a member of the Coast Guard is generally like kind of a pretty intensive, like full-time thing. They were clearly like, to go back to the Gardner example, like he was literally like living in the ship at the time, so his employer was providing housing for him, so it was a pretty strong thing of it.
Has anyone here worked for the Coast Guard? I think one year I taught a class and someone did. Does anyone here have a military background? Yeah. Do you think most brand new members of any military organization are more like an employee or an independent contractor? Employee. Why?
You're very dependent. You don't have the ability to even go get other employment. When you have a military contract, you have just that. It is a contract with that employer that outlines everything.
So when you woke up every day, did you decide, well, this is what I think I'm going to do today. I'd like to do this, or I'd like to do that. You're kind of told what to do, right? You're using the Coast Guard or the military's equipment, right? So I think this is probably a pretty easy case for finding Lane as an employee, not as an independent contractor, right? Coast Guard's equipment, Coast Guard ship, telling him what to do, don't think he had a lot of control. Shouldn't be too hard. Now, the second issue, however, might be a little bit tougher, right? We have to ask whether Lane was acting within the scope of employment during this incident. Let me ask for another vote. How many of you think Lane should be viewed as acting within the scope of employment when this incident arose? And how many of you think no? All right, we're pretty evenly split. That's good. Now we can have a good discussion. Those of you that said no, Lane was not acting within the scope of employment. Why not? How would you make that case? Yeah.
I think since you mentioned before they're allowed leave at some points, and I'm guessing that Lane was on leave at that point, and coming back, that kind of references maybe that he was not within the scope of employment, and it seems like getting drunk is definitely not within employment standards at that point.
Okay, so he probably wasn't thinking he was going to serve the Coast Guard by going out and getting drunk, and you're saying we should view what he's doing as still coming back from his detour to go to bed. How's he serving the Coast Guard, right? He's just coming back from shore leave. Other thoughts on that? Other people want to bolster the argument?
I would add that, like, using the water valves is not foreseeable results.
Okay, so you're working with the second test, right? There's sort of the purpose to serve, and then there's the foreseeable test. And you're saying it's not that foreseeable that a sailor would come back drunk, spin a bunch of valves. I'm with you, right? I never heard of that happening before. I read this case. Some people might disagree. We'll get to that in a second. What about purpose to serve? Purpose to serve. I mean, really, on this purpose to serve, I should emphasize that this is the dominant test, right? The sort of scope of employment. Do we think that what he was doing was within the scope of employment? There's at least one argument that's no, because he was just kind of coming back. Anything else we can say about that?
I mean, I'm kind of thinking of like purpose to serve in kind of like a benefit way, like we talked about with the previous case.
Yeah.
It's like when you work for someone, you're supposed to benefit them. And so I don't know if you could justify, of course he was drunk, whether he thought that doing this was going to benefit his employer.
Yeah. So if, I should actually flip these, right? Because we're going to put scope of employment here, right? One way you could have your scope of employment was trying to have a purpose to serve. The other would be whether it was foreseeable. That's probably the better way to actually look at the test. All right, some of you that argued that the answer is yes, this should be viewed as being within the scope of employment. How would you make that argument? What would you say? Yeah.
I would say like the valves are on the site of the place where he's employed.
Okay.
And he's only returning to the ship because he has to live there.
All right. Going back to the ship because he lives there.
Yeah.
And the valves don't attach to the ship, they attach to the dry dock.
Right. But I would say they're connected enough to the place of employment. And
Okay.
you know, obviously they're at the
Sailors sometimes spin valves.
Right.
What? Yeah, go ahead.
He wouldn't have been there if he wasn't employed by the Coast Guard, most likely. He was only coming back there because that was the place
Okay.
arranged for him by his employer to stay.
All right, that's where he was supposed to stay. Yeah, Nathan?
Kind of a little bit of combination of those two is that like he can, the presumption of him being in an authorized only zone is to do to be part of his employment.
Does that,
Secondly, like,
sorry.
To turn the valve maybe in a badly conscious state, but maybe he's still assuming I'm doing something for the.
Okay. I like where you're going with both those arguments. One sec. What do we think was going through Lane's mind when he was spinning the valves? Like if we had to guess. Spin the valves. My job's to spin the valves.
I think you could maybe make a presumption that he thought he was doing something like constructive for the job.
Okay. It might be interesting to know along these lines whether he ever spun valves before, right, as part of his duties. Because I mean, there's at least a couple theories, right? Theory one, maybe he kind of thought he was trying to help, right? I mean, that's what you're saying. Like, my job is to spin valves. I'm coming back. If I spin these valves, that's, normally what I do. It might also be that he was behaving maliciously, right? I mean, woo, let's spin the valves, right? I mean, that could be too. And that, I think, would very much feed into whether we could view this as having some kind of a purpose to serve. Yeah?
I think there's a very strict level of control there, because I think the case says that he had to go back onto the ship a very specific way. So he was being directed by the Coast Guard. This is the gangplank that you have to walk on. This is what you have to go by.
Yeah.
And so they were exercising that control. You can't stay on shore if you're drunk. You have to get back on the ship. So you
Okay.
can go this way, even if it causes you to do something. Maybe he thought, ship out of water. I got to put the ship back in the water.
Yeah. So, I mean, in order to have this being viewed as within the scope of employment, normally we're going to be asking the question that we've been talking about, right? Was there a purpose to serve while he was doing this? So I think usually it would not just be enough that you were physically there, but are you actually trying to help further the interest of your principal when you're carrying out this specific activity? Or if those of you, who've suggested this want to make the argument that just being physically there is enough, you might then ask, well, does that mean that anything the agent does ever while they're physically on the ship is going to be something the Coast Guard's going to be responsible for? The case actually tries to distinguish a couple things where that might not be true. Yeah, your hand was up.
Oh yeah, so I was going to say something along the lines of that to reinforce that is the fact that there was a contract between the government and Bushey that specifically said that workmen shall have access to the vessel at all times.
Yeah.
Which means that any time that they're at the vessel kind of indicates that they are under the control of their employer, and so any actions committed within that area would be underneath that contract.
Okay, and there may be a contractual relationship, right? But what we're also asking now is whether there's an agency relationship that falls under Respondeat superior. And so I think we're going to want to probe a little bit deeper, right, into these other elements. Let's talk a little bit about what the court actually decided here. We've got, a pretty short opinion. We've pulled out the best parts of it, and we've got a nice judge named Judge Friendly, right, who's deciding the case. Does Judge Friendly think that Lane was acting within the scope of employment because he had a purpose to serve?
I mean, my interpretation of it is he just says that that we don't know, and he kind of says it's not enough for us to know. There's no way to tell how what he was doing while he was drunk, and so we should use a different method to decide.
Okay. Yeah.
Kind of says that we shouldn't necessarily use this test. It's more of a test of what is a foreseeable possible action.
Okay.
What's a reasonable precaution we can take, which he says the state did.
So let me correct my elements here, right? The major thing we've got to decide is scope of employment, right? If this happened within the scope of employment, then we've got this plus this, and we can have Respondeat superior. The critical test that we've been talking about is purpose to serve. And as some of you suggested, there is this alternative foreseeable result test. I want to drop down to that in a second, but first I want to really hammer home whether Friendly uses purpose to serve or not. Does he?
He doesn't. He says that there is no way to know what was going through Lane's head at the time, so with that being the case, you can't really say there was a purpose to serve.
Look at the bottom of the paragraph, first page, second column, paragraph starting the government attacks imposition of liability. Right? Last few sentences there. It would be going too far to find such a purpose to serve here. Right? I think that's Friendly cluing us off that, I don't think purpose to serve is there. We've got to cross this off, right? This is actually a really interesting case of legal reasoning, just to sort of preview coming attractions. In the common law, right, we rarely have cases where the facts are exactly the same as the case that we're deciding. Certainly that's true here. And so one of the lawyer's tasks is to try to say, let me go out and find the closest case I can and figure out whether this case is like that close case or whether it's not like that close case. And so in this case, the lawyers actually had an interesting situation. There was another case involving drunken sailors that had to do with purpose to serve under the Respondeat superiority test. And Friendly sort of looking at the case above, I guess it was a drunken sailor who hit one of the other sailors to try to get him out of his berth. And the case there said, Yeah, purpose to serve. He's trying to get him to go to work. But even for Friendly, this fact pattern was different than that. And so he was distinguishing that perhaps similar case by saying, well, sailor, drinking, maybe kind of purpose to serve, but no, not here. It's going too far, right? I don't know what's going through his head. If we did have some sort of a historical record, a brain scan, right, of what Lane was actually thinking, then maybe the outcome could have been different, but that's not true. So Friendly says, this is out. Purpose to serve. What about our foreseeable test? Is that going to work here?
I think they talk about in like the first line of last paragraph of the second page.
Yeah.
It says mention that this is a person with qualities when they look for work. So it's sort of taking like since you hired him and you know sort of his characteristic that you can sort of foresee how this person will be.
So this is foreseeable. This is something we should expect is going to happen. What do the rest of you think? Is this foreseeable?
I found entertaining Judge Friendly's argument that it's known that sailors get drunk.
Okay. Is it known that sailors spin valves and cause ships to topple over at damaging dry docks? I never heard of that before.
I was going to say something that stood out to me was how much he did it. Like,
does that make it more foreseeable or less foreseeable?
Like in my head, way less foreseeable.
Yeah.
Because, like maybe you do it once or twice or something, and then you, like even like no matter how drunk you are, in my opinion, you don't spin valves 20 times.
I would contend that if all of you had thought about the situation before you knew what happened and had to make a prediction as to whether some drunk sailor would come back and spin valves and damage the dry dock, no one would think that's a foreseeable result. Friendly seems to say this is foreseeable and therefore Coast Guard's going to be liable. How can Friendly come out that way? Yeah.
I think given sailors' proclivity for drunkenness,
okay.
Even if you don't know the exact circumstance, whether it's throwing punches into the ocean or throwing people into the ocean or spinning a valve,
yeah,
they might do something, you just don't know.
So one strategy, whenever you're a judge and you're trying to, I won't say manipulate, but I just did. When you're trying to work with legal tests is to, let's change the zoom lens a little bit, right? What's foreseeable here might not be the case, but let's zoom out a little bit. And as you just described, right, maybe it's not foreseeable that this exact problem would happen, but with this basic setup, it's foreseeable that some damage might arise to the dry dock. And if that's the standard of zoom back enough, that now we can make out a proper Respondeat superior test. Your hand is up. Okay.
He said it was foreseeable that there could be damage even just in their daily duties, even if he wasn't necessarily drunk. Like there could just be damage to the dock at any given time.
Let's engage in a moment of legal realism, right? Legal realism is where we sort of look away from what the judge is saying that he or she is doing. We look at why they're actually doing this. Any hypotheses or theories as to why is Judge Friendly decided this case the way that he is? I mean, this, I think even he can't say is present. So he's dropping down and really adjusting this foreseeability test, which is really not a commonly used test, in a way to find the Coast Guard liable. Any thoughts? Yeah. I know I put you on the spot.
Maybe just because he's saying it could happen in the future, and like maybe he's trying to set some kind of precedent for like how future similar dock damage cases could be decided.
Okay, maybe he's trying to set up some sort of a future strategy. Yeah.
I mean, like if you have any situation like this in the future, like if he said you can only find Lane liable, then like who's going to be brought to call for this in the future? Like if this dry dock owner can only seek compensation from this guy who doesn't have any money, then like any number of damages could be caused with like no way to find any like fair outcome.
Okay, you said it. The F word, right? Friendly uses the F word 3 times in the last few sentences of this opinion, right? It's fair, it's fair, it's fair, right? Friendly thinks it's fair. Now, I want to ask the next question. This is something, we've now figured out the contours of what the law is. We've applied the law to a specific situation. We've changed the test a little bit. We've come up with a rationale for changing the test. It's fair. Now, I want to ask an interesting question. Given this result, what do we think the incentives are going to be for actors going forward? Is this going to be good? I mean, the goal here, right, our goal generally should be to try to prevent these dumb things from happening. Going forward, is this decision going to do that?
I think, yes, it does, because it provides a level of recourse for these companies working with the government. If the government was entirely shielded, why would independent dry docks ever want to work with the government if they could never seek recourse for?
Okay. I mean, they could just increase the price they charge, right? That might be one strategy. We want to try to take action to prevent this thing from happening. What are we going to do?
I think the Coast Guard may take too much precaution
Okay.
to prevent this from happening, like maybe not letting sailors leave the boat at all, or like breathalyzers or something.
Okay.
To really restrict their, I don't know if those are things to
Yeah, I mean, I like the path you're on, right? Like, the question we should be asking is, what steps could have been taken to prevent this bad thing from happening? And who would be in the best position to take those steps? One step would be breathalyzer, right? I assume that the Coast Guard would have to be the party that's taking the breathalyzer test, yeah.
I think the problem is it seems like he's moved the level of generality back far enough where it's like there's an increased scope of what is predictable. Because
Yeah.
it's like, he's saying, he kind of makes a claim that, oh, you should be able to, the Coast Guard should just be able to understand that this will be something that occurs. But it's not exactly clear how the Coast Guard should go forward in trying to calculate liability in the future.
So we should hone in on the specifics, and then we should do what you're suggesting, which is let's back it up and say, was that going to be enough? On the specifics here, what's the thing that could have happened that might have prevented this from taking place?
I were the owner of a dry dock, and I had 3 valves that were very easy to unravel
Yeah.
and cause immense damage. Personally, I would put locks on them or make them...
Just lock the frickin' valves! Just lock the valves, right? Especially if 3 of them are going to damage your dry dock. So does that suggest that this case got it exactly wrong? Because by imposing liability on the Coast Guard, now the future Busheys of the world are just going to say, well, we don't need to lock the valves. We'll just recover from the Coast Guard if this thing happens. Maybe we decided this case exactly wrong, and now we're going to put incentives on a party that's not in a position to take them. Is there anything the Coast Guard could do to prevent this from happening?
Well, I mean, like the ship was docked because they were like doing repairs on it. Like they weren't like sailing the ship around. So like, why did the Coast Guard need to have the sailors still living on the ship?
Okay, so yes, to answer my own question, which you just did, right? Don't have the sailors live on the ship. Put them all up at the Four Seasons, right? And let them take their short leave there, right? Or install breathalyzers, right? Or be more careful with who you hire, right? I mean, all these things are plausible implications. Now, we should ask one follow-up question. Let's imagine that the case came out the way that it did. And now the Coast Guard is sailing another ship in, and it's expensive to put everyone up at the Four Seasons, right? And so we want everyone there, and we don't want to buy the breathalyzers. And we know that there's a possibility that the dry dock isn't going to have locked its valves. And we've got sailor lane number 2, right? Floating around. If you're the Coast Guard, what would you do? Yeah, in the back.
Your contract, they have to lock the valves.
Okay, we will use your services, but you must lock your valves. That's one of the interesting footnotes into the case. And so there's a famous article by Ronald Coase that talks about the situation that says, look, all you really need is clear law. Because once the law is clear, parties will just bargain to what the best precautions are. And if the Coast Guard's going to have to pay, then they'll just insist that the dry dock owner lock their valves. Which is interesting, right? Because maybe it doesn't matter which way we go as long as we're really clear about it, which kind of comes back to your point. Is this decision going to be clear enough at the end of the day, the parties are going to know what to do? Not for the valve problem, that's been settled, right? But the valve problem is never going to come up. It's going to be, as some of you suggested, someone shoving someone else off the ship or something else happening. And it might not be 100% clear, right, where the occurrence is going to be. So you can see the court wrestling with that a little bit at the end when they're trying to say, we're going to use this alternative test. It's fair. It imposes liability on the big Coast Guard, and they should be paying. And maybe some people have complained that this doesn't give us certain enough law. Yeah, maybe, but we'll figure it out. And you can question whether or not that's satisfactory, but that's kind of where the court is going here. Okay, we have time for one more quick case. Again, let me set the stage here. It's a beautiful day in Fenway Park. The Red Sox are playing the Orioles. I see we have an Orioles fan right here in class. And it turns out that warming up on the pitcher's mound is a guy named Ross Grimsley. Here he is. He's an Orioles pitcher. You could perhaps tell from his baseball card around what time this case was decided. is getting ready to come in, and it looks like he's going to need to help out the Orioles. Well, there's this fan. I don't know where the bullpen is here, right? Somewhere in the back, I guess. There's a fan kind of sitting right next to the bullpen. His name is Manning. And Manning is just heckling Grimsley like crazy. Grimsley, you're the worst! Grimsley, you can't pitch at all! Grimsley, I hope they send you in, right? It's going to be wonderful. And so Grimsley is kind of just ignoring him. And then eventually, he sort of winds up like he's going to throw, pivots 90 degrees, throws the ball right at Manning. Ball goes through the fence and damages Manning. Manning's hurt by Grimsley's beanball. Assume Manning is upset and hurt. Assume Grimsley did something that was legally wrong. Again, put your attention in the plaintiff's lawyer's corner and say, if you represented Manning, who might you sue? Yeah. The team. Which team? The Red Sox?
No.
Why not sue the Red Sox? They're the ones that put in the faulty fence. They put in this fence with holes. Does he want to sue the Red Sox?
No.
Why not?
Because Grimsley is more associated with the other team, which I forgot.
Okay, it's the Baltimore Orioles and the Red Sox.
I'm not a fan.
He's a fan, right? I mean, that's his team. He might be kind of grouchy that they didn't build a better fence, but he's not going to sue his own team. Red Sox are off the table, let's assume. But you're saying there's some other defendants.
Right.
Who? Grimsley. First off, let's go after Grimsley. Right? He's the jerk that threw the beanball that hit me in the head. And he did. He sued Grimsley. Now, that wasn't enough for Manning. I don't know if Grimsley had a resource problem like Lane. Baseball players get paid a lot. I don't know if they got paid that much back in the 70s. And so it's possible at least that Grimsley didn't quite have enough money. But also he's got the dream, as you're suggesting, of suing the Baltimore Orioles. Every fan's dream, right? Let's go after the Orioles. Manning sues Grimsley and the Orioles for negligence and battery. We can assume that Grimsley's going to be responsible. The interesting question for us is whether the Baltimore Orioles are going to be responsible for Grimsley's tort under a respondeat superior theory. What do you think? Yeah.
I feel like no, doesn't it have something to do with it being full of malice and willful, or like just the fact that he did this maliciously, Grimsley?
Okay.
Should, in my book, kind of absolve the Orioles from any responsibility.
If we were working within our respondeat superior test, I don't know if you can read my chicken scratch, what might that suggest is lacking? Like what might be missing if you are correct that, okay, maybe it's not foreseeable. Why wouldn't it be foreseeable?
Why would it not be?
Yeah.
Because you don't know how someone's going to act maliciously or out of character or against the law.
Okay, it's not foreseeable to expect that an agent is going to really go off and act in a very wicked way on their own.
I also wouldn't say that that's his purpose to serve. I mean, he's supposed to play for the team and benefit the team.
Yeah.
And if he's turning around and throwing a ball at someone, that's probably not what he's supposed to be doing in the scope of his job.
A lot of what we're doing here, right, is we're trying to distinguish a bad actor from themselves as a bad actor as an agent or a servant of the corporation or the legal entity. And I think both of you are right. Like if we should properly understood that what Grimsley is doing here is just him flying off the handle as a hothead and doing something malicious or intentional, then maybe that's Grimsley acting as Grimsley, not Grimsley acting as the Orioles pitcher. Yeah, in the back.
I kind of argue that it is kind of foreseeable because it's foreseeable that he would get, not exactly foreseeable, but it's foreseeable that he would get heckled.
Okay.
And that the team should have established with him that he can't do that. You know what I mean? If he's in the scope of employment, he's actively in a game.
Yeah.
It seems like they could be liable.
On a clear day, we can foresee forever, right? And maybe this is a good example of that. Anyone want to talk quickly about the employer versus independent contractor element? Do we think he's an employee, independent contractor? Yeah.
Well, I don't know a ton about baseball, but I know usually the contracts are not extended. There's a finite end to the term of the contract.
Do we think Grimsley just decides what he wants to do, or do we think the team has a fair amount of control over what he's got to do?
The team has a fair amount of control over him.
Probably, yeah. Thoughts?
He plays for the Orioles. He doesn't get to, in the next game, play for a different team.
Yeah.
He only gets to play for this team, so therefore he's not.
He's using their equipment, right? Their time. I think he's probably viewed as an employee. So the question again is going to come down to whether this is within the scope of employment. I've heard some suggestions that this might be foreseeable. I've also heard some suggestions that this certainly would not be within the purpose to serve. Thoughts?
Well, pretty much every opposing, he's at the opposing team's ballpark. Pretty much every pitcher ever has been heckled by fans, and almost all of them don't do what he does.
Okay. Okay. Does anyone want to make out a theory that he might have been acting with a purpose to serve the team when he did this? Yeah.
Yeah, I was gonna say, like, I don't know a ton about hockey, but I feel like in hockey, it's often like to rally their own team.
Okay.
So arguably, by throwing the ball, his team would rally in his favor.
Okay. Maybe like if I hurt one of the fans, we got a lot of hands now, then we'll really get going.
Well, I think that's a public-facing goal, like generally. I mean, you
Yeah.
have baseball cards, you make media appearances. I think that the like PR element is central to being a professional athlete.
And part of the PR is punching other fans in the face or throwing a beanball. Okay, so he's not serving. Your argument is he's not serving the Orioles by doing this.
He's having relationships with the fans, and him managing that is part of his job.
Orioles fan, last word? Anything?
Well, I mean, his goal, or the team's goal there is to make the home fans as miserable as possible.
Yeah.
It's kind of an extension of that. He just took it a little too far.
Here's what the court said. Lower court dismissed the claim and said there's no litigation against the Orioles. On appeal, the court reversed and it said, we think it's at least plausible that Grimsley might have been having trouble getting ready to go in and pitch. And the way he got himself ready was by quieting the heckler by throwing the beanball. And so it was in the furtherance of the Orioles' mission so that he could then go in and pitch. And the Orioles kind of settled the case. So I'm sorry, they lost, they settled at least. Let's step back for a minute, right? We have got just a couple minutes left. I want to ask, we now know kind of what the law is, but it's possible that the law is wrong. Again, a lot of what you're going to be dealing with in law school is the question of, well, here's the law, but is it right? We've talked a little bit about what it is, why we have it. Now our question is whether or not it makes sense, and it's possible that it might not. Maybe this isn't the best legal approach to Respondeat superior liability. And so I want to ask you to think about it in the following terms. Let's imagine that I own a fireworks store. Here it is. And we can imagine this fireworks store operating in a variety of alternative parallel universes. Parallel universe number one might be a universe where the principal is never liable for the torts of his or her agent. So I own the store, I hire a bunch of people to run the store, various customers shop in the store, but as the principal, I'm never liable for the torts of my agents. Ever. Would you like to live in this world? Shaking your head, no. Why not?
Well, I mean, your employees could be shooting bottle rockets off at the customers, and you have no way to. They're harming your business. You have no way. Defendants have no way to recover.
Well, if they're damaging me, I could presumably sue them, right?
Customers then have potentially no way to recover though.
Okay, they could recover from my employees. My employees are all going to be 16-year-olds, right? Yeah.
As an agent, I wouldn't feel safe working in a place where a principal has no motivation to protect me or my
Okay. My rules are going to be smoke all you want. There's no fire extinguishers, right? Come work here. Now, Ronald Coase would say it doesn't matter which way the entitlement goes. Everyone will adjust. And so as an employee, you might bring your own fire extinguisher, right, when you walk into work every day and carry it out and protect yourself that way. Many of us, I think, would be nervous about this world, right? We kind of like situations where there's someone standing behind a problem beyond just the individual agent who does it. What about the flip side? What about a universe where the principal is always liable for torts committed by your agent? Always. You want to be in that world?
I feel like that's probably not good. I feel like that would strongly discourage you from opening or continuing to maintain the store, because I feel like basically anytime there is any risk of anything, you'd be like, maybe let's see it, I have to shut it down.
Yeah. Certainly it would make me nervous about opening up the store. What else might it do? Yeah.
If your agent like commits a crime at home, technically.
They're my agent, yeah. We're linked. No, we're linked. Always.
Yeah, so your agent could break someone's window by accident.
Yeah, I mean, it gets back to the malicious comment, right? As soon as you hire anybody, whatever they do, they'll be responsible for it if they've done a legal wrong. But so are you, because you're their principal and you're linked in the back.
Yeah, I mean, you just wouldn't want to hire certain types of people which have a high risk of crime. Like you might say young men, we're just going to write them off.
Yeah. Yeah, I mean, there might be different pockets of society that are implicated. My 16-year-old son would never get a job, right? I mean, just because who he is. I don't think many of us would like to. He's a wonderful kid. I don't think many of us would like to live in that world either. And so the world we live in, for better or worse, is this kind of middle ground, right? Principals liable for the torts of their employees if they're closely related and if they've got a fair amount of control over what it is that the agents are doing. Right? And the goal here, as we now recognize, is to internalize some of the possibility of harm. And by internalizing the harm as a corporate or a principal at the principal level, hopefully we'll put the right incentives in place that allow people to take precautions that will prevent these bad things from happening in the first place. And maybe there's also an expectation that if a principal or a corporation is going to benefit from having a broad array of people and resources doing work for them, they're also going to be responsible for, covering things when there's a problem. That's the policy goal. At the end of the day, as you've already seen, legal resolution of these situations is going to turn on really fine details, like the ones we've been talking about. This is the type of thing that drives non-lawyers crazy, right? We're parsing these tiny things. Why are we even doing that? But in part, in whole, it matters, right? This is the type of stuff that actually matters. And what you're going to be doing next year is spending a lot of your time figuring out what matters, where do we draw the lines, give one type of legal treatment versus another, and then arguing about whether it should matter and whether it's the right, the best, the just outcome, or whether we should be changing the law. Okay, thank you so much for being here today.